On the record in the matter of the people of the state of Michigan versus Jason Mcoles, file number 22-01643, council appearance. Yeah.
Don't know.
Apply. Show up. You apply for court and return at a meeting. Mr. Raleigh,
Yes, Your Honor.
are you representing Mr. McCombs? He applied for court appointed counsel.
I am not. I believe John Lee is.
Sign it.
McCombs? You're representing Mr. McCombs?
I'm sorry, yes, I am. Your Honor.
Okay. Today was the date set for a probation violation hearing. Are we having a hearing today?
Actually, I do not believe we are, Your Honor, but I need to talk to him for 5 minutes.
Okay, off the record on that. On the record in the matter, the people of the state of Michigan versus Trina Kutin, file number 23-02351. Yes, please.
Panel was out on behalf of the people.
Member John Lee on behalf of Trina Kutin.
Off the record on that. But Mr. Lee, who else do you have?
I have Deontay, Chapman.
Mr. Raleigh, who do you have?
I have Daniel Melton.
Let's see. Two files for this person. Put names in most of these. Let's see.
That's a fresh,
Which one?
Chapman.
Here.
I think it's.
Or it's just signed. Oh. Mr. Lee's logging in. I think he's going to see what's going on. On the record in the matter of the people of the state of Michigan versus Daniel Melton, file number 22-00598, council appearance.
Assistant Public Defender Jacob Riley appear on behalf of Mr. Melton, Your Honor, who I believe is in the county jail.
Mr. Melton, can you hear us?
He's not been brought up on video yet, Your Honor.
Oh, he's downstairs. Or is he?
Oh, no, he's in post 2.
He's not on video.
1 and 3.
I just see someone on, okay, they didn't put him on it. Got it. They're probably waiting for these others to be cleared out. Okay, well, looks like we're actually. Mr. Lee, you're meeting with Mcoles, is that correct?
That's correct, Your Honor. Thank you.
Mr. Warren, your light went off. You have to stand up and make some motion to make it come back on. There you go. I asked his wife about it. Okay, let's see, on the record in the matter, the people of the state of Michigan versus Daniel Melton, file number 22. I'm sorry, not Melton. Who did you just meet with? McCombs, I'm sorry. Jason McCombs, file number 22-01643, council appearance.
That's the Chicas for the people.
Assistant Public Defender John Lee on behalf of Jason McCombs.
Okay, Mr. McCombs, you can hear us?
Yes, Your Honor.
Okay, today was the date set for a probation violation hearing. You were previously arraigned on the violation. And you requested court-appointed counsel, and you're represented by Mr. Lee today. Mr. Lee, are we going to proceed to a hearing today?
No, Your Honor.
Okay, so he wants to plead guilty to the violation.
Yes, Your Honor.
Oh, it's not all. I thought it was all, that's on the date. It's the violation from 2022. Alright,
I got both the old ones today.
okay, so I have a violation. The defendant failed to appear for sentencing on May 1st, 2023. Is that correct? That's a violation. Okay, very good. So that's what you want to plead to, sir?
Yes, Your Honor.
Well, if you ever, how do we have a violation if you never appeared for sentencing?
I don't think this is the one for sentencing. I think this is, I'm seeing one that he failed to report to probation since September 2023, when there was a warrant that was never taken care of and never set up testing.
Yeah, I see in the recommendation that he never set up testing, but I don't see that violation.
On April 24th, I have a note that he appeared at a hearing and we discussed this. And I believe he admitted to the violations that time. Although, there was some talk about sentencing, whether he would need to be enrolled in a program or not, because he was looking at CMH and Sacred Heart. So we were going to see how that played out, but he didn't come back for sentencing.
Sentencing on the violation.
Correct.
That makes sense. That's what I'm saying. I don't have another violation in here since then.
Oh,
Got it.
he was sentenced on the offense.
He was sentenced on the offense, and then there was a violation after he was on probation. He appeared, and then he did not appear for the sentencing of the violation. And so he told the magistrate that he was in rehab.
Yes, at that point in time, he was looking to get into a CMH sponsored program at Sacred Heart. He reports that after he missed his sentencing in May, he did enroll in a program at Bear River in July and completed that program in October of 2020.
Oh, so he wasn't in rehab when he failed to appear.
I do not believe so.
So he just blew off our date.
I heard of this.
Mr. McCombs, why weren't you here for your sentencing date back on May 1st, 2023?
There's not a whole lot of excuses. Your Honor, at that time, my mother was just diagnosed with stage 3 cancer, but she's in stage 4 now. And I was trying to keep as much time around her as possible while staying in communications with the courts. Now, I did do the 90 days at Bear River. However, when I turned myself in on that violation, the report read that it was a felony charge. And the judge told me that I could not turn myself in via the computer. I would have to do it in person. It was, like I said, there's not a whole lot of excuses behind it. I was worried and worked up about the felony charge. I didn't know how that worked, and I apologize. And I had explained to further public attorney what was going on with those circumstances, Your Honor.
He has another felony? Oh,
So he was concerned, somebody had given him some information, and he was concerned that that's what was happening. That in fact was not what was happening. He just needed help. He did not attend his court date. He was not in good cause. Eventually seek help from Bear River in July. Reports that he completed that program in October.
okay, sounds good. You can make allocution on sentencing.
Thank you. Mr. Mcoles, since the completion of this program, reports that he has been working in school. He says that he is an English major and will be starting back again in the fall.
He's been working and in school.
The employment part, no. He collects Social Security disability income,
But he's in school.
and he's in school, yes.
Where is he enrolled in school?
Mr. McCombs, where are you enrolled in school?
I'm Lansing Community College. I'll be starting the fall semester.
Does he have proof of his enrollment?
You have proof of your enrollment?
I'm not on me, but I'm sure it's nothing to get to call up there and confirm that, we're gonna processes to.
You said you call up and confirm what?
I said I don't have proof on me, but I'm sure it wouldn't be anything to call and confirm that I'm definitely enrolled. I haven't done my financial aid yet, but I have done my appeal from the last time I was there and, gone further in enrollment, and I'm definitely starting in the fall.
Oh, so you haven't started, you're trying to start. There's a difference,
I've
correct?
not started yet. I've not started, rather, no.
Okay,
So he would be starting school in the fall as an English major, he reports. This is the whole process that we're going through today is difficult for him. He has been prepped for oral surgery. Has been experiencing some pain, some difficulty in communicating. But he does want the court to know that he has addressed some of his substance abuse issues. He's been compliant with his meds in regard to his mental health. And he asked the court to consider the recommendations of the probation department to terminate probation and give him credit for time served. He would like to spend as much time with his mother as possible. Her cancer has progressed to stage 4.
oh, you said his mother has cancer, not him.
That is correct.
So I sentenced him to 18 months probation. He absconds, doesn't do anything. He comes back eventually, and I try to give him a second chance because he tries to blame it on his financial situation. He goes MIA again. I'm being told that he did some treatment, but I don't have anything that proves that. So I don't believe it until I see it, because he's not giving me reason to believe anything that comes out of his mouth. And then I'm supposed to say that because he got picked up earlier this month, that we should just call it a wash. 18 months probation should be a wash because you've been in jail since July 8th. Is that what you think?
I've been in my program the whole time with Monica Jane, and I thought she would be in court today. And I apologize for the impression that I gave off. I sure do. I've had a lot going on, which goes for, I never wanted to be disrespectful towards the court, Your Honor. I apologize.
Yeah, well, unfortunately, you were ordered to do many things, and one of those things was to follow the court orders. You've not done any of those things. And so you're gonna do more than get time served, that's for sure. I am gonna terminate your probation because you're not a good candidate for probation. You don't follow the court orders. And so you will remain in custody for 60 days. Ingham County Jail. I'll credit you for the days that you served, but you won't get any additional early release, meaning there won't be any GPS tether release. You're gonna do the full remainder of the balance of the 60 days in custody. Because when you don't follow court orders, when you're given an opportunity to be on probation, then that means you want to go to jail. So don't come and cry all of the bad things that are going on later. You should have thought about that when we gave you all the chances we could, including me trying to find a way to have you avoid the cost of probation. Because I specifically noted that you complained about your inability to enroll in testing because of financial things. Because you were not following the court orders and you weren't enrolling in random drug testing, even though this is a incident that you were placed on probation because of the need of your oversight because of substance abuse. So 60 days Ingham County Jail. With credit for the days that you served so far. Any additional matters for today's record?
Not completely, Your Honor.
Nothing for the defense.
Your balance of your fines and costs will be referred to collections. That's $485. You need to make a payment arrangement when you get out on that $485, otherwise you'll get notice of a show cause hearing and another breach warrant get issued because you didn't pay the court fines. Okay,
Yes, sir. Yes, sir.
you're all set.
Thank you, Your Honor.
CO, court officer.
I'm sorry.
Oh, okay. We know who's representing Mr. Warren.
Warren, I don't know.
No, I think Jake. I never seen him. Oh, yeah. 20,000.
Did he request court appointed counsel? It was entered that, it says Warren Sutter. He did request court appointed counsel.
System. He might, sometimes those things just don't get turned in.
It's also a 2009.
Well, that doesn't matter. He was arraigned, he requested it when he was arraigned.
Oh, gotcha. Okay.
Warren Sutter listed in here. Yeah, they listed Warren Sutter as his public defender for the probation violation, but I don't know.
That's it. You should be able to see it. And I'll say,
Yeah,
as far as we go.
just.
There you go.
Oh, yeah. So does the board.
I don't have him in the system at this time, but we do have Warren Sutter with him, so yes, I will be glad to represent him. and
Okay,
talk with him.
let me arraign Mr. Chapman and then you.
Stand, I cannot have him step out.
He doesn't have to, this is gonna do the arraignment.
Okay.
Okay, on the record in the matter of the people of the state of Michigan versus Deontay Antoine Chapman, file number 24-02043, council appearance.
Yes, good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Deontay Chapman.
Okay, Mr. Chapman, I have a felony warrant here. It alleges that on or about December 23rd, 2020 through January 14th, 2023, at the area of 1419 Rio Road, that you did allegedly commit the act in count 1 on or about December 23rd, 2022, of knowingly restraining Ariana Richardson with the intent to engage in criminal sexual penetration or criminal sexual conduct with that person, and that this was contrary to Michigan compiled law 750.349. There's a Sex Offender Registration Act notice. It says this is a tier 3 offense under the Sex Offender Registration Act if the victim is a minor. Count 1 is a felony. The maximum penalty is life in prison or any term of years and or $50,000 in fines, and your DNA is to be taken upon arrest. It says on or about January 14th, 2023. And count 2, you're being charged with a home invasion first degree, alleging that you did break and enter or did enter without permission a dwelling located at 1419 Rio Avenue in the city of Lansing, Ingham County, state of Michigan, and while entering, present in, or exiting, did commit an assault. And while entering, present in, or exiting the dwelling, Abriana Richardson was lawfully present therein, contrary to Michigan Compiled Law 750.11A2. Count 2 is a felony with a maximum penalty of 20 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. He's definitely frozen. Can you hear us in the jail? Okay, can you hear us, Mr. Chapman? That's frozen.
Yes, ma'am. It keep going in and out.
Okay, we're gonna see if they can address your device, because I don't know if you heard me read all of count 1 and count 2. Did you hear that?
No, ma'am. I can't hear you.
Okay,
No, I can hear you now, ma'am.
okay, very good. Okay, I'll start from the beginning. Okay, very good. Okay, again, I have a felony complaint here that alleges that on or about December 23rd, 2022, I think this is what it's supposed to say, and January 14th, 2023, at 1419 Rio Avenue, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 on or about December 23rd, 2022, of knowingly restraining Abriana Richardson with the intent to engage in criminal sexual penetration or criminal sexual contact with that person, and that this was done contrary to Michigan Compiled Law 750.349. There's a Sex Offender Registration Act notice. It says, this is a tier 3 offense under the Sex Offender Registration Act if the victim is a minor. Count 1 is a felony with the maximum penalty of life in prison or any term of years and or $50,000 in fines, and your DNA is to be taken upon arrest. There's a count 2 on or about January 14, 2023, alleging that you committed the act of home invasion first degree, that you did break and enter or did enter without permission. Frozen again. Mr. Chapman? Hello?
Judge, can you hear us in here? Judge, can you hear us in here?
I can hear. It's because you have another device.
Yeah, we just put it in. Yeah, we just put it in on another.
Okay, very good. Can you hear us, Mr. Chapman?
Yes, ma'am.
Okay, from the beginning. I have a felony complaint here that alleges that on or about December 23rd, 2022 through January 14th, 2023 at the area of 1419 Rio Road, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 on or about December 23rd, 2022 of kidnapping. It alleges that you did knowingly restrain Abriana Richardson with the intent to engage in criminal sexual penetration or criminal sexual contact with that person. And that this was done contrary to MCL 750.349. Count one has a Sex Offender Registration Act notice. It says this is a tier 3 offense under the Sex Offender Registration Act if the victim is a minor. It's a felony, that is, life in prison is the maximum penalty, or any term of years and or $50,000 in fines, and your DNA is to be taken upon arrest. Count 2 alleges that on or about January 14, 2023, you committed the act of home invasion first degree, alleging that you did break and enter or did enter without permission a dwelling located at 1419 Rio Ave, City of Lansing, Ingham County, State of Michigan, and while entering, present in, or exiting, did commit an assault. And while entering, present in, or exiting the dwelling, Ariana Richardson was lawfully present therein, and that this was done contrary to MCL 750.110A2. Count 2 is a felony with a maximum penalty of 20 years in prison and or $5,000 in fines, and a consecutive sentence may be imposed under the law if the under the law for a conviction arising out of the same transaction. Count 3, unlawful imprisonment on or about January 14, 2023, alleges that you did secretly confine and knowingly restrain Ariana Richardson or knowingly restrain Ariana Richardson to facilitate the commission of assault by strangulation, a felony contrary to MCL 750.349B. Again, there's a Sex Offender Registration Act notice attached to count 3. It says this is a tier 1 offense under the Sex Offender Registration Act if the victim is a minor. It is a tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 3 is a felony with a maximum penalty of 15 years in prison and or $20,000 in fines. Count 4 and count 5 are both charged as assault with intent to great bodily harm less than murder or by strangulation. One alleges that on or about December 23rd, 2022, and the other alleges the date of January 14th, 2023. Both allege that you did make an assault upon an Ariana Richardson by strangulation or suffocation, contrary to MCL 750.84. Count 4 and 5 are felonies, maximum penalty 10 years or $5,000 in fines. DNA is to be taken upon arrest. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 6, on or about December 23rd, 2022. The allegation is that you interfered with a crime report or committing a crime threatening to kill or injure. The allegations is that you did injure, retaliate, attempt to retaliate, or threaten to retaliate against another person for having reported or attempted to report a crime committed or attempted by another person by threatening to kill or injure a person, contrary to MCL 750.483A2B. Count 6 is a felony. The maximum penalty is 10 years in prison and or $20,000 in fines, and a consecutive sentence may be imposed for any other conviction. Count 7, on or about December 23rd, 2022, the allegation is that you committed the act of domestic violence and that you did make an assault or assault and battery upon an Ariana Richardson, an individual with whom you had a child in common or a resident or former resident of your household, or an individual with whom you had a dating relationship, and this is contrary to MCL 750.812. Restitution may be ordered in count 7 as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Count 7 is a misdemeanor, maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is, however, a second offense notice attached. Says take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.812 on or about December 11th, 2018, and therefore upon conviction, he will be subject to an enhanced sentence under MCL 750.814. Restitution may be ordered as this may have resulted in damage to another individual's property or physical injury or death to another individual. The second offense notice enhances the domestic violence to a misdemeanor with the maximum penalty of 1 year in jail and or $1,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Lastly, there's a count 8 of domestic violence with the date of on or about January 14th, 2023, alleging you did make an assault or assault and battery upon our Brianna Richardson. Again, an individual with whom you had a child in common, resident or former resident of your household, or individual with whom you had a dating relationship. There is a second offense notice on that as well. Again, enhancing your maximum penalty to 1 year on count 8 and or $1,000 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Did you hear all of the counts? It's counts 1 through 8 and the maximum penalty, sir.
Yes, ma'am.
Okay, you do have the right to be represented by an attorney. Mr. Lee, your attorney on another matter, is here to represent you on the arraignment on this matter. You have the right to be represented by counsel at each appearance on this criminal prosecution, and you have the right to be represented by an attorney if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office appointed to represent you at the expense of the public. You understand your right to counsel, sir?
Yes, ma'am.
Okay, did he want to make a request for court-appointed counsel?
Yes, Your Honor.
Okay. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, the matter will proceed all the way to a jury trial. You have the right in this matter to have a preliminary examination because you're being charged with felonies, and you have the right to have the preliminary examination within 21 days of today's date being the date that you're being arraigned. At the time of your preliminary examination, you have the right to require the prosecutor meet their burden of probable cause. So you can require them to put forth evidence to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You're currently scheduled for probable cause conference before me, Judge Kristen Simmons, August 2nd at 9:30 in the morning. You have a preliminary examination before me Friday, August 9th at 9 o'clock in the morning. You'll receive a notice to appear from the jail, okay?
And when you said, when is my next court date now?
On this file, it'll be August 2nd at 9:30. That's a Friday, and then your preliminary examination will be the following Friday after that, August 9th at 9 a.m.
Okay, so when do I get seen on my probation violation?
We're talking about a felony right now. We're not skipping files right now. I recognize you have multiple pending files, but we're not done with this.
I'm
Okay?
sorry, ma'am. Yes, ma'am.
Okay. And so back to the felony. You have the right to have a trial. You can proceed to trial in this matter. You have the right to the presumption of innocence. So you're innocent until proven guilty. And you have the right to require the prosecutor prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses the prosecution intends to call against you. You can call your own witnesses to trial or present evidence that you believe show a defense to the charge being brought against you. You can waive your right to silence and testify on your own behalf. Do you have any questions about those rights?
No, ma'am.
And we know that you're on probation or you're on parole.
I believe on probation. I was on probation.
You're not on parole?
No, ma'am, I don't believe I'm on anything.
Oh, okay. Well, you're on probation, but other than that, okay. And you have other, you do have other matters pending in other courts?
Yes, ma'am.
Okay. What's your home address?
3125 Choppers Cove Trail. Apartment 3B, Lansing, Michigan 48910.
What's your phone number?
810-874-0259.
Are you employed?
Yes, ma'am.
Where are you employed?
Storage unit. It's a moving company, and I just recently got accepted at the gas station down the street from my home.
Okay, you can address the bond, counsel.
Thank you, Your Honor. Your Honor, this is a very serious matter involving a plethora of felonies across multiple offenses, including life offenses, as well as discretionary consecutive sentences. My office feels this defendant is a significant risk to the community and to the victim specifically. He was on bond for domestic violence against this same victim when he committed these acts with a no contact order in place. He has specifically threatened to murder the victim, the eyewitnesses to these crimes, and her family members if anyone were to contact police. And he has threatened her with that more than once. He has assaulted her in front of the minor children and in front of eyewitnesses. He has had family members help him contact and intimidate victims in the past. He has a history of stalking her electronically and showing up where she is without warning in order to frighten her. And now, to be clear, I signed this complaint in February of 2023. I have no idea why it took this long for it to get sworn to. But in the meantime, he's picked up a new criminal case for stealing from this victim, and he's picked up a new domestic violence case with a different victim, which, interestingly enough, the victim, he gave the other victim's address as the place that he lives at, 3125 Trappers Cove Trail, apartment 3B. And I'm pretty sure there's no contact order in place. So it looks like he's violating that one too. Because this is a pattern for Mr. Chapman, as it's a pattern that he keeps beating and harassing and threatening women, because that other victim was also terrified of the retaliation she would get if she spoke with police that day, as is noted in their report. So my office is incredibly worried about what this defendant is going to do and what he is capable of doing, which is why, as in the bond form, I'm requesting $500,000 cash surety with a GPS tether and exclusion zone for the victim and eyewitness, because he's threatened to murder both of them. And I believe that that is an appropriate bond, Your Honor.
Counsel.
Thank you, Your Honor. Mr. Chapman has several matters that are pending. He has not been found guilty of any of them as of yet. However, as the counsel noted, he clearly is in violation of his no contact order, showed up here with the complaining witness in the other case and gives her address as his own. However, it doesn't lend so much credibility to the prosecutor's argument that he's such a dangerous man and this woman is so terrified of, not the one that we're talking about, but the one that brought him here. That being said, Your Honor, the bond at the court's discretion.
Could the people be allowed to respond to that lovely
Yes,
piece of
counsel.
information? I could go
Yeah.
on for about 2 straight hours of the dynamics of domestic violence and
Just
how
don't-
through power and control. I'm not going to, because the court's heard me do this
It's 3
before.
o'clock. It's
Yep.
3 o'clock, and we gotta get people out of here before 5, so.
I think that makes it
Take your
clear
time,
the
but
risk
not
he
2 hours.
poses. I think that fact makes it very clear the risk that he poses in this case. And that very much makes me worried and feel that that bond request is appropriate, Your Honor.
Yeah, I would disagree, Mr. Lee. I think if someone is operating, and I think we all have had some experience with getting understanding about the mindset of victims who are in domestic violence situations. I can't speak to why a victim or protected party in another matter would accompany him to court today for a violation on a domestic violence with another victim. The other victim, ironically, being the same person named in the case I just arraigned him on 8 counts on, which means that if true, while he's on probation, he's violating my probation and no contact order by having not just contact with the protected party, but some harmful and dangerous and assaultive contact with that alleged victim, and then comes to court with another victim from another case, because I think he's got more than one pending domestic violence at this point before this court, and then gives that address as just now to the court, that victim's address as the place where he's living at this time. I think that speaks to blatant disregard for court and authority, is what I think it speaks to. And I think that if true, Mr. Chapman thinks he's above the law and that above reproach, and has no regard because he's going to do what he wants to do. I've reviewed his prior criminal history. I've reviewed the bond recommendation report that was provided by the prosecutor's office at the time that the warrant was authorized. And I want to also touch on the fact that I too don't understand what took so long for it to be processed, but I see that Judge Flores signed this just last week. So as soon as it was just recently signed. And so because we had him in court today, I did have him remanded immediately to have it addressed. Don't know where the tie-up took place before then, but we're here now. The concerns iterated in the bond recommendation is that there's a concern for the protection of the public as cited in MCLA 765.6, that the defendant is currently on either probation or parole and has other pending criminal charges. In this case, he's on probation for the same similar action with a victim that's same or similar, and has other criminal charges pending, another assault of domestic case pending at this time before this court. The defendant has been charged with violence towards another person. The defendant has a history of violent behavior directed towards this victim and other victims. History of threatening and or harassing behavior toward the victim or witnesses, and that there was an intimate partner relationship between the parties. Other factors of risk of lethality in the domestic assault situation is indicated here, that the defendant exhibited or demonstrated threats to kill the victim or the victim's family, that he exhibited some stalking behavior or forced or threatened forced sex acts. There's an escalation of violence or risk taking over time, and attempts to isolate or prevent the victim from reporting, and that the crime committed was done in the presence of children, and other information which was already iterated on the record by Mr. Pfeiffer. The people are again requesting bond, 500,000 cash surety with GPS tether, exclusion zones for victim and eyewitness. The court will definitely be imposing a cash surety bond. I don't think $500,000 is necessary, but we will do a bond of 150,000 cash surety with GPS tether and victim notification. The court is going to say this portion very slowly. While you are in the custody of Ingham County Jail, and when you are not in the custody of Ingham County Jail, you are not to have any contact of any kind, directly or indirectly, with the alleged victim. Do you understand that?
Yes, ma'am.
You're not to have anybody else contact Brianna Richardson on your behalf. Anybody else, for example, would include your girlfriend or the person that you're not supposed to be bringing to court with you because there's a no contact order. Anybody else could include your mom or your sisters or your neighbors. Anybody else could include you trying to use another inmate's number to make a phone call, because I can tell you that the reason why I've given those examples is those all fail. There's a recorded phone call. Ingham County Prosecutor's Office listens to the recorded phone calls, and you will be prosecuted for the violations, in your bond conditions and your privileges while in custody could be revoked. And I can guarantee you, if you're waiting to post bond, it could get a little bit more stressful if you lose your phone privileges because you think you're smarter than the court order. Do you understand that?
Yes, ma'am.
Okay, and so we'll see you at your next court date. You can appear at your probable cause conference via Zoom. You must appear in person for your preliminary examination. Again, bond is $150,000 cash surety with GPS tether. While out on bond, again, there's a no contact order protecting, in this file, Brianna Richardson. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance unless you have a valid prescription. You need to report to pretrial services within 48 hours of your release. Do you have any questions about your bond conditions?
Yeah, yes, Your Honor. If I was to post a bond, would I be able to get out today, or I was gonna have to sit?
If you can post the bond, you can be released. You have to post $150,000 with GPS tether. And we need a valid address, because you're not gonna be able to go to the address of 3125 Trappers Cove, because that's an address that you already have a bond violation for, I'm sorry, a no contact order for, which I'm assuming is going to be an issue of a bond violation in just a moment.
Yes, ma'am.
What is is there a bond with that address?
There is, Your Honor. I'm sorry, I have to go back to it. He just bonded out yesterday. He was given, I believe he bounded out with $55. So
With that, and that address is the victim?
and that address is the address for the victims, the address in our system. I'm not sure.
And I have that case?
You do, yes. It's
Okay.
set for a pretrial on August 6th.
Okay, I'm gonna revoke that bond. Pending a bond violation here. Any other questions?
Ma'am.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Thank you.
Thank you. You're all set, Mr. Chapman. We'll reset your probation violation. I don't think you want to address that today.
So with my bond being revoked, it's no point of basically it's no point of me trying to bond out.
I can't advise you of that. You gotta talk to your attorney about what's in your best interest. But I just got notice of a bond violation on that file. So now I have to revoke that till I can address that. And I'm not addressing it today because we've given you more than enough time today. I've got other people waiting.
Yes, ma'am. Thank you.
You're welcome.
Thank you, Your Honor.
Thank you.
I think you're all set.
Hi, I'm watching, bro.
Right then.
Oh, so.
Brought him on. I don't know why they never put Mr. Melton on. And then Mr. Warren, Mr. Lee's gonna log in to meet with you.
Okay.
You spoke to somebody, Mr.?
Mr. Warren, so yeah, those two should be ready to go.
Okay, on the record in the matter of the people of the state of Michigan versus James Warren, file number 09-0538. Council Chambers.
Assistant Public Defender John Lee on behalf of James Warren.
Okay, today's the date and time set for probation violation hearing. Let's see. And this is an old case. Are we having a hearing on this?
No, we are not.
Okay, the allegations are that he failed to report or comply with his probation since December 11. I'm sorry, December 2011. That his his probation must have been transferred to Grand Rapids. That he failed to make payments, monthly payments on his balance, which at the time was $1,903. He failed to complete the economic crime program and failed to attend AA and provide verification. So he wants to plead to all of those.
Yes, he is, Your Honor.
Is that correct, Mr. Warren?
Yes, Your Honor.
Raise your right hand.
I'll do the best I can.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can put your hand down. Do you understand your right to have a contested hearing?
Yes,
You want to give up your right to hearing today?
yes,
Anybody threaten you to do that?
no,
As to the violation that you absconded from probation since December 2011, how do you plead? Can you hear me?
yes, I plead guilty, Your Honor.
And as to the violation that you failed to make monthly payments on your balance of fines and costs, how do you plead?
I plead guilty.
And the violation that you failed to complete economic crime program as ordered by the court, how do you plead?
I plead guilty.
And lastly, the violation that you failed to attend AANA and CA with verification, how do you plead?
I plead guilty.
Factual basis, please.
Thank you, Your Honor. Mr. Warren, were you sentenced to a term of probation in the 54A District Court in regard to case number 0905383?
Yes,
And as ordered by the court, you were to report to your probation officer, you were to complete an economic crime program, and you were to make payments on that case, correct?
yes, sir.
And so did you fail to report to your probation officer in December of 2011 and January of 2012?
Yes,
And failed to make payments having a balance of $1,903 as of October of 2011? And there was a economic crime program that you were ordered to complete. Were you able to get that completed?
no,
Thank you. And then there was also the idea that you were going to go to, or you were ordered to go to AA and bring verification back to the probation officer. And in December of 2011 and in January of 2012, you did not provide verification, correct?
that's correct.
Thank you. No further questions, Your Honor.
Any questions from the prosecution?
Not professional basis, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea, find your plea to be freely, voluntarily, and intelligently. Does Mr. Warren fail to comply with the terms of probation here as well in Grand Rapids? He has been on bench warrant status since February 8th, 2012, before I even received my bar results. It is apparent that he is not a viable candidate for probation.
I don't disagree, Your Honor. I mean, the court could reinstate him to probation if it was inclined, but given the amount of time that has passed, I do believe that Mr. Warren is in a different place today than he was then. He reports and was quite forthright about some of the struggles that he has had with addiction and homelessness. He says that in the last 5 years, he's really done a lot better. He completed a 6-month adult rehab program at the Salvation Army. He completed a program at the Holden House 3 or 4 years ago and been clean ever since. He's been addressing his mental health issues. Reports that he has been independent. He's had an apartment for 1 year, works at Enterprise Mobility, and even volunteers from time to time at Cristo Ray. So, yeah, of course, at the court's discretion. We just believe that he's in a different place today than he was then.
And if people do have some additional information, Your Honor, I believe the reason that we have Mr. Warren with us today at all is because he does have a pending case in 54B. That is a matter where he has pled guilty, but sentencing has not occurred yet, nor has it been scheduled. He pled to domestic violence. It was originally, I believe, domestic violence third as a have four, I believe. And we dismissed the repeat offender notice and the have notice in exchange for, I believe, what was at the time a delivery for no upfront jail.
What was the date of incident on that?
I can pull that up in a moment, Your Honor. And there was also a note on that same file that bond was at that prelim bond was modified because he said something, he had mentioned something about not being allowed to go home. And that was a part of the bond. So I don't know if that is a misconception connected to this case.
I don't know. There could be any misconceptions of after 11 years of not showing up.
Let's see if I can pull that up. That was the offense for the domestic violence was January 7th, 2024.
Oh, so he's been going to court and they don't, you didn't know he had a pending warrant? Where you been, sir?
Pardon me?
Where have you been? Why are we just now seeing you on this pending case?
Well, I've been here, Detroit. Just kind of, like I say, just homeless. I haven't been arrested in just different places. Like I said, I had alcohol,
why didn't you turn yourself in on this warrant?
Well, I didn't know that it was still a warrant. I had been stopped by the police, and no one had ever said that there was a warrant for it. Because I would have taken care of it because, you know, like different places, even jobs and things I've applied for. I didn't know that it was a warrant for that, and I'm being honest with you. I didn't know. When it came back, there wasn't nothing said. I was let go, so that's pretty much. And you know, and plus my alcoholism and drugs addiction and all that stuff played a part in it. So that's all I can say. So that's the only excuse I have.
They put that his balance was $2,283, but he only owes to him. That's what I was thinking. Okay, sounds good. You owe $2,283.
Yes, ma'am.
In restitution. Since 2011.
Yes, I can, I do, and I acknowledge that, and I can actually pay some of that now, and I'm able. I got a good job, so I can. If you want payments, I can have that paid within 6 months or sooner.
What is he in custody for?
If it's from, I don't actually know why he's in custody at this point.
Things on this bench.
Just this? Man for PH per Jersey. Okay, so how much you gonna pay this week?
I can pay. I can pay 300 by what is today? Tuesday. I can pay 300 by Friday.
And when are you gonna make your next payment?
We can set that up. I can do, and this I'm gonna be honest. I can do 250 to 300 a month if that's and get that taken care of. And that's being comfortable with paying my bills and you know being able to eat and things like that. I'm just being honest with you.
Okay, I'm gonna note here that you'll make a payment of $300 within the next 7 days. You'll pay a minimum of $250 on by the 30th of each month there following until your balance is paid in full. I'm discharging you unsuccessfully from probation credit time served. Any additional matters for the record?
Not Your Honor.
Nothing for the defense. Thank you.
You're all set, sir.
Okay, thank you.
You're welcome. Okay, and then, is that Melton?
Yes.
Okay, on the record in the matter of the people of the state of Michigan versus Daniel Melton, file number is 22-00598, counsel appearance.
Abigail Wilson for the people.
Jacob Rowley on behalf of Mr. Melton.
Okay, today was day set for a hearing on a probation violation. Are we having a hearing?
It's my understanding that Mr. Melton will be pleading to the violations.
Mr. Melton, you don't want a hearing?
Oh, I know. What was that?
Do you want to have a hearing or do you want to plead guilty to the violations?
For the violations again?
The violation that I have is that he committed a new offense on October 4th, 2023 while on probation and pled guilty to that offense on December 5th, 2023. The 55th District Court case 23-023014191 and FY pled guilty to count 2 of disturbing the peace, pled guilty to count 3 of attempted police officer assault resisting obstructing. Is that what you recall, sir?
Yeah.
You want to plead guilty to violating your probation by committing a new offense while on probation?
Yeah.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
Yeah.
Thank you. You can put your hand down. Okay, you have the right to have a contested hearing and you're electing to give that hearing up. Anybody threatening you to get you to not have your hearing? Any promises being made to you in exchange for you pleading guilty to this violation? As to the violations that you violated your bond by pleading guilty to a new offense in the 55th District Court, how do you plead?
Guilty.
Factual basis, please.
Mr. Melton, is it true that you were placed on a term of probation by this court in July of 2023?
Yeah.
Is it true that on December 5th of 2023, you entered a guilty plea on a new case in the 55th District Court?
Yeah.
Is it true that you pled guilty to crimes of disturbing the peace and attempted assaulting, resisting, or obstructing a police officer?
Yes.
Is it true that the date of those offenses was October 4th of 2023 and that you were on probation as of that date?
Yes.
Any questions from the prosecution?
No, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea. I find it to be freely, voluntarily, and intelligently made. The recommendation states that is recommended to terminate probation and impose jail time. It says that the defendant's acceptance of responsibility was poor and his overall progress was poor. It says defendant also on probation at 55th District Court for new charge committed while on probation, and he never met to even begin probation in this court. You can discuss sentencing counsel.
I think Mr. Melton is probably not a candidate for probation at this point. It has been a while and he's picked up new offenses. I am also seeing on the 55th online ROA that it looks like he's scheduled tomorrow for a probation violation in his 55th case. I think that at this point, a term of incarceration would be appropriate, but I would leave the term to the court's discretion and request any fines, costs, or restitution that's remaining in the court in the matter be referred to collections.
Mr. Rowley.
Your Honor, yes, I do think overall the recommendations are fair and appropriate. I know that Mr. Melton has a number of mental health issues, which when he's not taking his medication and participating in counseling, things overwhelm very quickly. And I think being on probation for 2 courts is perhaps a lot for him to deal with during this time. If you know that his probation in 55th District Court sort of oriented toward a mental health strategy. I think I can't verify based on my records, but I think he was at least screened for the mental health court there. And maybe a mental health court participant, but like I said, I can't verify. But regardless, he remains under the supervision of that court and does have a hearing scheduled for tomorrow between 4 in the afternoon, where his future and that probation file will be determined. So I would ask, well, frankly, I would not dispute the recommendation to terminate his probation in this court at this time.
When he was placed on term of probation, he didn't have another probation going on, so he can possibly use the excuse that he got overwhelmed because he was doing 2 probations. Mine's preceded the other, and the only requirements that I gave him was to participate in mental health counseling, report to community mental health, and be compliant with his medication and treatment. That was the only thing that I required him to do. That can't be, if that's overwhelming, then you have to go to jail. Because we can't force you to take your meds. Mr. Melton, you gotta stand up and move around because it's motion censored, so. Okay, then, because how else can we ensure that he's gonna take his medication if he can't do it on his own?
They said I didn't have to take medication last time I was there, but it's up to me if I want to take medication or not.
I can't hear you, can you say it louder?
Last time I went to mental health, they said if I didn't want to take the medication, I didn't have to be doing it. And so I quit taking medication because I said I didn't.
So they say if you didn't want to take the medication, you didn't have to?
Yep.
Why didn't you do what you were supposed to do for probation?
I don't know, I just, I got, I just couldn't make it out there. There's one bus went out there once a week. I couldn't get it. Yeah, I couldn't make the bus. They just go out there one bus, go out to Mason once a week and make, I live in Oakland, so I had to go way down the Mason one. And going 1 week and I couldn't make it, so I just couldn't make it there. Yeah, so I gotta play with my brother.
Your brother is here in court.
Yeah, my brother there.
Your brother's here.
Well, I couldn't make it there, so I had to go homeless. And I've been homeless ever since, but I'm trying to make it.
Okay, I'm gonna discharge him from probation unsuccessfully. He'll get credit time served. The balance of 305 is gonna be referred to collections. You're all set, sir.
Thank you.
Let's see.